Hello guys, and welcome to another episode of my lecture. On today's episode, we will be talking about without prejudice admissions, whether or not they are valid admissions that could be tendered as evidence in a court of law. In my previous class, I spoke about admission in previous proceeding by a party, and I told you on the authority of Awoke versus Owoduni that they are valid admissions that can be tendered as evidence. In this class, we'll be discussing whether or not without prejudice admission can be tendered as valid evidence in a court of law in Nigeria. Note that in certain cases, the court will prohibit giving evidence of an admission where it is obvious that the admission was made on the understanding that there would be no disclosure of the admission without the consent of the person making the admission. These are admissions made without prejudice when parties attempt to settle a dispute out of court, and we can see that our authority here is section 26 of the Evidence Act. And what does section 26 say? It tells us that in civil cases, no admission is relevant if it is made either upon an express condition that evidence of it is not to be given, or in circumstances from which the court can infer that the parties agreed together that the evidence of it should not be given, provided that nothing in this section shall be taken to exempt any legal practitioner from giving evidence of any matter of which he may be compelled to give evidence under section 192. Now, our proviso here is not relevant to our lecture. What's extremely relevant is what the wordings of section 26 of the Evidence Act says. That's the real substance of the section. Now, what does the substance of the section tells us? It tells us that no admission will be relevant if it is made upon an express condition that evidence of it will not be given. Now, the essence for section 26, as stated in our Evidence Act, is so that people would be encouraged to settle dispute out of courts. If you get to our Nigerian courts today, you will realize that the Supreme Court calendar as at December 2021 is already in 2024. So which means that if you are to appeal any decision from the Court of Appeal, currently right now, let's say 3 Court of Appeal justices sat on a case now and they gave a judgment now, there is no date in the Supreme Court calendar in the whole of 2022 to hear the matter. There is no date in the Supreme Court calendar in the whole of 2023 to hear the matter. The matter can only be heard in 2024. That is, if not a later date in 2024. Because it might clearly not be the earlier dates, that's January, February. Now, because of the way our court system has been congested with a lot of cases, the Evidence Act is trying to make sure that disputes are settled out of court. So if there is a dispute between party A and party B, let's say party A is a petroleum refining company or something like Shell, or a petroleum digging company, which means that they go into the ground to dig up petroleum and stuff like that. So like Shell, let us say Shell for example. So Shell went to a village in Delta State, and then when they got there, they found that there was like a large quantity of oil in the ground, and then they decided to try to take the oil from the ground. But while doing that, one of their pipe burst. Do you understand? And then it spilled all over and all that due to negligence and things like that. Now, the people of the Delta community sent a representative to Shell to let them know that this thing has caused a lot of damage. Now, while they were in the meeting, which was obvious that the essence of the meeting, although not expressly stated, but was stated in circumstances that the court can infer that the essence of that meeting is to make sure that they settle the dispute out of court. Now, that's to show you that there are 2 ways that section 26 can operate. Number 1 is where it has been expressly stated in the document without prejudice, even if it is not stated in the document, but the court can infer from both the document and the circumstances around that this particular engagement between these 2 parties was to the effect that this engagement was to come to a conclusion, or that they were supposed to settle this particular matter out of court. So in this case, Shell then called the representative, they sat down for a meeting. Shell admit certain negligence, admit certain responsibility, and offer to pay them 10 million. But they are saying that the extent of the damage that have been caused on the farmland and the fact that the livelihood of the people in this particular community has been taken away. 10 million naira cannot take away the damage. Talk more of recuperating the soil that the oil has damaged. Talk more of the time that it will take and how the people of this particular community are supposed to fend for themselves during the time that they are trying to, take away the damage that has been done to the land. 10 million naira is too small. And then Shell said, well, that's what we have. Now, they now went to court. And then in court, they now tried to tender the evidence where Shell admitted to wrongdoing, admitted to negligence, admitted to spilling oil on the floor. And then the court in that particular case, first of all, before he would admit that particular admission, the court have to look at whether or not the admission was made in such a situation where they were trying to come to a settlement of dispute. If the admission was made in that particular caveat, then the court is more likely to reject that evidence because it falls under the exclusionary evidence of section 26. Do you understand? It falls under the exclusionary evidence of section 26, and with that, I hope you totally understand how section 26 works. So yes, we know what admission is, but admission of this nature would not be admissible in courts. So with that, we then go to my next lecture where I will be discussing who can make admissions in courts. Who are the people that can make admissions in court? I will see you in my next class.